To give is to receive. The benefits of a charitable remainder trust. I'm David Parker with the Law Office of David Parker, and this is another entry on my video blog. A charitable remainder trust, CRT, is an irrevocable trust for the benefit of a charitable cause, into which you can transfer assets or investments, and from which you can derive income for life, or a fixed term not greater than 20 years. If set up for life, the trust can be extended through the lives of your children or even your grandchildren. The trust takes advantage of the nonprofit status of its beneficiary. The rules governing CRTs are found in IRS Code Section 664. You might say that a CRT is the gift that keeps on giving, or perhaps more accurately, it's the gift that goes on giving back. A CRT is a way to have your cake and eat it too. With this instrument, you can give money to a charitable cause while at the same time investing it and enjoying the fruits of the investment. A CRT can provide substantial tax savings as well as the satisfaction of charitable giving while aiding in income management and New York estate planning. As far as taxes are concerned, the important thing about a CRT is that it allows for flexibility in planning for the uncertain future. The returns are like those on any other investment, which in this economy tend not to be all that impressive. As a result, the tax benefits may not be all that impressive either. However, we can't be sure what the future holds in the way of taxation. There's a lot of public pressure on Congress to raise the top marginal tax rates and close existing tax loopholes and deductions beneficial to corporations and those of high incomes. We cannot know what will happen as a result of next year's election, or what the government may do in response to the current crisis, both economic and fiscal, that beset the nation and the government itself. If government remains divided, on the other hand, the Bush tax cuts may be allowed to expire. This requires no new government action at all, and this would raise the capital gains tax rate from 15% to 24%. At that point, the tax savings from a CRT would become very substantial indeed, making it an important tool for New York asset protection. One thing to remember is that a CRT is an irrevocable trust. Once created, it can't be dissolved at will. Careful consideration of the options and consulting legal counsel are therefore recommended. This is David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. Charitable giving in an estate. This is David Parker with the Law Office of David Parker and another entry in my video blog. Using a part of your estate to help charitable causes you believe in can leave a legacy of helping out others, patronizing the arts or scientific research, or furthering other worthy goals. It works a little differently than charitable giving in life. Giving to charities during life is something that most successful people feel a desire to do. It can share one's own success and good fortune, giving that fortune forward. It can help causes and activities that one believes in, from helping out those who are less fortunate to supporting the arts and sciences to helping a favorite social cause. Charitable giving is often also tax deductible and an aid to New York estate planning. With the state of the economy and politics at this time, though, donors may want to be more cautious than usual. Only the largest estates over $5 million are liable for the payment of estate taxes, but there is talk in Congress of changing that. Changes in the income tax code may also be expected, although exactly what changes can't be predicted, either to income and capital gains taxes or to estate taxes. For all these reasons involving New York asset protection, it often makes good sense to defer at least some charitable giving, reserving it and including it in a bequest or trust in one's estate. Bequests represent a decision that isn't final until death. You can adjust your will to accommodate changes to tax laws or circumstances as appropriate. Bequeathing an IRA to a charitable cause may be especially desirable. A charity, being tax exempt, does not have to pay income tax on IRA distributions as your heirs would have to. Depending on the type of asset, there are many different vehicles and methods for leaving a bequest to charity. This is David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. This is David Parker with the Law Office of David Parker and another entry on my video blog. Small business owners should beware of undercapitalization. There have been a number of cases recently in which the corporate veil was broken and a sole proprietor found liable out of his personal funds primarily due to undercapitalization. Business owners should not rely on limited liability without taking adequate precautions and making sure they are adequately capitalized for their operations and obligations. Limited liability protects the owner of a corporation by separating the corporation's funds from personal funds, so that liability is normally limited to the assets of the corporation. However, it is not a perfect defense, and for purposes of New York estate planning, as well as other reasons, this should be kept in mind. In Bogosian versus All American Concessions, Marty Rosen, the owner and sole shareholder of the sole owner corporation, All American Concessions, discovered this to his sorrow, as reported in Forbes. The problem was undercapitalization, combined with failure to obtain proper insurance as his contract required. In 2005, the United States Tennis Association signed a contract with Restaurant Associates to provide concessions for the U.S. Open. Restaurant Associates subcontracted the beverage side of the concessions to All American Concessions. All American was required to obtain insurance as a condition of its contract with Restaurant Associates, but Rosen failed to do so. A class action suit against all three companies, USTA, Restaurant Associates, and All American, hit Restaurant Associates for $92,000. RA sought payments from All American and Rosen declined to pay. Naturally enough, RA sued All American and sought to pierce the corporate veil and seek compensation from Marty Rosen in his own name. This effort succeeded, and Rosen, not just All American, was found liable for $92,000. Rosen did a number of things wrong that other small businesses owners should be aware of and avoid. He did not keep paperwork and records as he should have, and so was unable to provide documentation during discovery. But the biggest mistake he made was to fail to provide sufficient capital to the corporation to cover operations and obligations. The additional failure to purchase proper liability insurance, which would have covered the obligation from the class action suit, leaving Rosen out only the insurance premiums, left All American with insufficient funds to cover its obligations in the matter. The corporate veil is a powerful defense, but courts tend not to look with favor on a sole proprietor who hides behind it to avoid contractual obligations or responsibility to the public by undercapitalizing the corporation. New York asset protection can suffer badly, not just in terms of corporate assets, but privately held assets as well. Owners should bear this in mind and make sure the corporation is endowed with sufficient resources to cover any reasonable contingencies. This is David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. This is David Parker with the Law Office of David Parker and another entry in my video blog. The $1 Million List. Indiana University's Center on Philanthropy has created a free searchable database, the $1 Million List. It's a reference of over 60,000 charitable gifts, each of them totaling $1 million or more, and made since the year 2000. The $1 Million List is a database compiling all available information on publicly announced charitable giving worth $1 million or more. The data are organized into charts according to several metrics. You can search it by state, by type of organization receiving the gift, or by the names of donors. The list allows identification of geographical patterns or of what types of organizations are over or underrepresented. You can tailor your own giving accordingly for the most beneficial effect to your New York asset protection and support for your favorite causes. As charitable giving can be an important tool for New York estate planning, information related to charitable giving is especially useful. Or you can take cues from the philanthropy of the famous, if you'd prefer to do that. Warren Buffett and Bill Gates, senior and junior, and family, lead the list of givers, not surprisingly. Here are some of the interesting statistics that can be found by searching the $1 Million List. 70% of all $1 Million gifts are made by individuals, not by corporations. Almost 7,000 of the gifts were made by people who made only that one gift of $1 million or more. These tended to be the larger gifts, totaling almost 40% of the dollar amount, but only 11% of the gifts. An article in Forbes offers additional information. The $1 Million List can be an informative tool to help understand how charitable giving works in practice when done in a big way. This is David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. This is David Parker with the Law Office of David Parker and another entry in my video blog. Medicare enrollment window opens early this year. Time once again to enroll for Medicare. This year, though, enrollment opens about a month earlier than usual. Surveys show that many seniors don't know this. Don't miss this window. Kaiser Health News reports a recent survey of seniors in Florida in which nearly two-thirds of those surveyed were unaware of the change to the Medicare enrollment window this year. The open enrollment period is now October 15th to December 7th. Failure to obtain the Medicare card by the end of open enrollment can leave seniors in the predicament normally suffered when it's not obtained by January 1st. Which means that being a creature of habit can be a problem this year, especially if you tend to leave things until the last minute. Just remember to enroll for Medicare by Pearl Harbor Day, a date most of those eligible for Medicare can easily keep in mind, and you'll be fine. The earlier open enrollment window is one of the several changes to the program arising from the Patient Protection Affordable Care Act, ACA. The details of Medicare plans have been changed, and the number of plans to choose from reduced. The intent is to make the selection of Medicare plans easier for seniors or their caretakers. Just as with the open enrollment date, many seniors leave the same Medicare plan in place year after year out of habit. This is not a good year to do that. Better to review the available plans carefully and be sure to pick the plan that will work best for you, or the seniors in your care. Picking the right plan for your expected expenses can save you hundreds or even thousands of dollars. Because of this, seniors concerned about New York asset protection and New York planning should pay special attention to those changes to the Medicare program. I'm David Parker with the Law Office of David Parker. I'm an estate planning and elder law attorney. Check out my other videos at parkertrustlaw.com.